Just believe us, we trying to teach you the rights to read you. It's just procedure, baby.
Trials, instruction, procedure. AWS gon' teach ya. Trials, instruction, procedure. AWS gon' teach ya. Here's a tip, don't get it twisted.
Welcome to Attorneys and Swag, the show you come to watch and learn about the law. I'm Eugene Toussaint, your host, and I'm here with my co-host,
Mehdi Essmidi.
And we have two very special guests. Introduce yourself to the audience.
Bryant Bell.
And Arielle Reid.
Yes. And today we have a very special episode. We're going to be talking about bail reform, that taboo word recently that everyone's trying to get you scared of from 2020. We're going to learn how it came into effect and exactly how it affects people's ability to get out of jail if they are bail is set. So, Mehdi, I know you've been on the show before, but give the audience a little bit introduction of yourself.
My name is Mehdi Essmidi. I am a private criminal defense attorney practicing here in New York City, all 5 boroughs and federally. I was a prosecutor for 5 years. I am now a private defense attorney. I also do family law, and I'm very excited to be here.
Hello, my name is Bryant Bell. I am currently a paralegal case handler in the decarceration project. I'm a formerly incarcerated individual. I'm a product of, the crack epidemic, a product of the crime bill, a product of mass incarceration. Despite all those conditions and those policies, here I am today. I'm currently an advocate. I advocate for parole justice. I advocate for to change the 13th Amendment so that it eliminates slavery under all circumstances, and that's basically what I do.
And I'm Arielle Reid again. I have been a defender in New York City for about 10 years. The first portion of my career I spent as an appellate public defender doing post-conviction work, trying to get folks out of prison. And then a few years ago, I transitioned to trying to get folks out of jail. I specialize in challenging illegally set bail, and I'm a huge proponent of ending cash bail generally, and in the meantime fighting to maintain as many of the meager steps forward we've been able to gain in spite of the rollbacks.
But okay, so for anyone who hasn't heard about the 2020 bail reform law, just break that down, exactly what it is and what role you played in it being passed, or what do you know about it?
Yeah, sure. So at the time the bail reform statute was initially passed, I was still a appellate defender, so I played no personal role in its passage, but it was a long effort of a lot of community organizers and affected folks and their families in coalition with defenders and other nonprofit folks in the criminal legal system reform space. A years long effort to reform New York's really draconian bail statutes. And so a quick and dirty sort of rundown of what it did was it made it so that judges could not set bail on certain misdemeanor and nonviolent felony offenses at the outset. Prior to bail reform, we saw judges were setting bail on things like turnstile jumping or stealing a bar of soap from Target. And the purpose of bail reform was to stop that practice of just setting bail on folks who were experiencing poverty and especially at amounts that they were never going to be able to pay. So that was the main thing that it did, was separate offenses into bail eligible and non-bail eligible offenses. The other thing that it did that was really important, even though this was part of the law from the very beginning, it wasn't really explicit and it wasn't really followed. This principle of bail being a means to secure somebody's return to court. It was inherently part of the law, but it wasn't spelled out as cleanly as the 2020 reforms did. So they made it explicit that the only reason you can set bail on someone if the crime is bail eligible is to ensure their return to court, not because you think they're dangerous, not because you think they're going to go out and, steal something else, and only to ensure their return to court. So even though that wasn't a substantive change in terms of what the law was supposed to have said previously, the fact that it was made explicit really hammered home that sort of latent principle that judges have been ignoring for a long time. And the statute also put in requirements about judges having to actually make a record. They can't just say, okay, I've listened to the arguments and I'm setting bail at X amount. They have to explain why they think the person's a risk of flight and why they think bail is necessary as opposed to some lesser restriction like supervised release or electronic monitoring or some kind of treatment program. So it was a really robust statute at the time. Obviously, there was a lot of debate and back and forth about, the discrepancy between bail eligible and non-bail eligible and who we're leaving out. And I think those were really important conversations to be had that were had. So it wasn't perfect even at the time it was passed, but it was better than what the law had been previously.
And I guess why is, I kind of understand why, but just for the audience, why is it important for the judges to state their reasoning? Why was that an important part of the statute?
Yeah, it was really important for judges to state their reasoning because that's the only way we can actually know whether they're following the law or not. So if the judge just says, okay, counsel, I heard what you said, I'm setting bail at, X amount, and doesn't say anything else about it, we don't know if they actually were considering risk of flight or not, or they're considering something else, or we don't know which factors in the statute that they relied on to come up with that amount. And so it really makes judges have to show their work so that if they are not following the law, there is a means for us, defense attorneys to challenge those decisions they're making. And
to basically rid it if we have to.
Yeah.
And Brian, what are you currently doing in terms of what's your role as in the decarceration unit?
When I started in the decarceration unit in 2019 before the law was implemented, right?
Okay.
And when I interviewed, I learned more about the work that the decarceration project was doing. And for someone like me that was involved in the criminal justice system, when I was going through the system, there wasn't people advocating. There wasn't this group, these coalitions that made these laws to make the bail process more equitable, right? So, I thought it was incredible to me, and so now as when we transition into the law being implemented in 2020. What I do is, I assist the attorneys in every aspect, obviously the trial attorneys in our office and the attorneys. I work with an attorney, her name is Danielle Welch, and I assist her. I assist the attorneys, I help them with PSBs, I help them with anything dealing with bail, either I.
Can you say for our viewers what a PSB is?
Oh, it's partially secured surety bond. So it's just so the reason why the bail law was formed to end cash bail, right? Because they wanted to determine based on instead of based on whether you're poor or not, they wanted to determine it based on public safety and individualized your risk assessment. So it goes based off whatever the statute says. So the judge has to make analysis based on that.
So the interesting thing is I'm pretty sure partially secured surety bonds were allowed prior to 2020, but I've never heard of a judge ever doing it.
Exactly.
But post 2020, it became an option, and I guess this is a good part of the show to just explain what are the different types of bail or circumstances of release that someone who is being arraigned can be set upon, it can be set on them.
Yeah, and I'll explain just briefly, because you're right that it was available prior to 2020 and judges didn't do it. So that was actually one of the lesser kind of known parts of bail reform, was that it mandated that judges now have to set bail in at least 3 forms. And one of those has to be either a partially secured bond or an unsecured bond. Judges don't like unsecured bonds, so that means that in most cases
I've never seen that.
Yeah, in most cases they're now setting partially secured bonds to meet that requirement. But yeah, just a brief sort of overview of the different types. So cash bail is like, I think, what most people think of when they think of bail. It's, you know, a set amount and you have to pay that full amount to the court, and that sort of is the trigger for your release. So if it's $10,000 cash bail, you have to go to court with $10,000. Yeah, and then the other types of monetary release mechanisms are things called bonds. So there's generally a few types of bonds. Partially secured bond, which is the one that Bryant mentioned, is it was supposed to be a way for folks who didn't have large sums of money to still be able to post for their client. The idea was that instead of having to put the full amount down, you only have to put a deposit, which is capped at 10%. So it can't be more than 10% of the full amount. It can be less, but we see that judges always like err towards the very top of the threshold. So most partially secured bonds are set at 10%. And so that means, like, if the partially secured bond amount is $100,000, you would only have to come up with $10,000 as a deposit. And the way it works is you go and you pay that deposit, and you're basically promising that if the person you're posting for doesn't return to court, then you're, you know, acknowledging that you're on the hook for the rest of the $90,000.
And in practice, that becomes the hard part, right? The ability to show that you can be on the hook for the other.
So basically, I'm transparent with our clients, and I let them know the pros and cons. Like, you could be eligible, you could be liable for this amount of money if the client doesn't show up, and you know, and they make the decision right there.
Yeah, I obviously to get someone to agree. I mean, in the sense of like getting proof of income, right? Because I know in Queens, basically you have to provide basically the equivalent of double.
Yeah,
you can probably get a little less. But most judges err on, like, if you want to safely go in there, you have to show proof that you can pay the other part to the point of double the amount of what the bail is.
And mainly, I've had a lot of success in you know, collecting those documents, helping the client navigate that process. And you know, I say majority of our clients, families, they do come up with the necessary documents to prove their income, their W-2 income. Yes.
And what's the necessary documents for the partially secured?
So all it requires is just you know, a W-2 income. That's in the Queens, they require double the amount of the bond. So if they have a necessary income, documents like, you know, W-2, pay stub.
I typically, whenever I have a client who is on bail and I'm talking to their family, I typically say, if you want to be safe, 2 to 3 months of pay stubs and at least 1 to 2 years of W-2s. So typically that will get past the hurdle.
Yeah, and I'll say, like, all of these things that we're talking about, these are not statutory mandates. These are things that judges have decided to do and as a means of weeding out folks. So the purpose of partially secured bond is supposed to be so that it's easier for folks to pay, and judges have come up with these arbitrary rules about, I want to see a salary of twice the bond amount, or I want to see X number of years of tax returns, and I want to see this, and I want to see that, as a means of making it not accessible to our clients' families in order to be able to pay. So it's a really perverse interpretation of the statute for judges to be requiring these sort of excessive documentations and excessive salaries. You know, if somebody, because they routinely set partially secured bond higher than cash bail, so like, you know, that's the most nefarious part.
Yeah, because like before, prior to 2020, you would have, let's say it's a gun case, $20,000 bail, right? You would get a bond, the bond would set the same thing. So now you have the ability, so bond is one of the other ways to pay bail. And the problem with bond is that you have to go to a bondsman.
Insurance company bond. Yeah.
Insurance company bondsman. Yeah, you go to a bondsman. You have to put 10% down, which they're gonna give to the court, and then which you're not gonna get back, and then you have to put collateral. The collateral you will get back, and they determine how much collateral based on, I guess, your credit worthiness or the assets you have, and then you lose that 10%. And in practice, what they would do is, you would imagine if pre-2020 it would be cash, bond, and then you're adding one, so partially secured, it should just be the same amount.
Yeah.
Which would allow that if cash is 20, bond is 20, then the partially secured surety bond should be 20. And what they will do instead is, all right, I mean, the most nefarious thing they can do is say 20, 20, 200.
Yeah.
Which is fucking insane. Because then it's like, partially secured surety bond is, I got to give you $20,000 and agree to,
and you got to show, they might want $400,000.
Yeah, which is insane. I mean, most judges won't be that bad, but they will definitely make it where the partially secured surety bond, instead of being 10% of what cash is, it's more like 30% or 40%, even 50%.
So we don't like to use the insurance company bonds, but sometimes like that's the last alternative where the client is forced to do that, because, like you said, they don't take the whole 10%, but they take a fee. Because there's legally what they can take. We got like
there's a maximum cap on
so they got to give a certain amount back
as a fee, but you don't get all your money back in the way that you do with the partially secured bond. Like, they're allowed to keep some of it.
I thought it was all.
Yeah.
I thought it was all 10%.
Yeah, so
it's a substantial amount.
But it's very like invasive. Like they'll ask for your financial information, your spouse's, her social security, all these things, because they want to like tie as many people to that debt. You know what I'm saying? So it's like, I don't really like it. I don't like it. And even though to me, from partially secured bond, I mean, it works in some instances, but at the same time, I think it just changed who profits from it. Because I still think that the state is because now we don't see a lot, but I do see some instances where the client doesn't show up and the family's on the hook. And, you know, it's the court that's demanding the money. I mean, there's ways to get it remitted. You know, you just file a motion or whatever.
So what is the process if someone doesn't show up? Because I've never been on that side of it.
The court will send you, they'll send the family, the person that's the obligor, they'll send them a court document saying you owe us this amount of money. They got to respond in a certain amount of time. So there's a remission. There's part of bail. I think it's in the bail statute. It's about remission of the bail if you owe it, if it's forfeited. So you basically, if you show that like the court didn't go through any further expense in the client returning, like for instance, if you especially if you like navigated, like you reach out to your family member and you said, listen, you know, turn yourself in or whatever the case may be. But as long as it wasn't like a process where it cost a lot of money, so there's a way to get it.
So they measure how much. It's interesting because it's like, these cops got to work regardless. So did you spend that money to get this guy to come back?
We talk about like, you know, like if somebody's, you know,
like they
manhunt.
They go out of state.
Yeah, and they, you know, something extreme, you know.
Okay.
And most people who miss court, like they're not, and I think this is the thing about the bail statute, that it's very clear. So first of all, most people don't miss court. I think 90+% of people return for all their court dates. Right. But the statute is very clear that the purpose of bail is to avoid flight from prosecution. And even people who occasionally miss court date, you know, because, you know, lots of folks who are going through the criminal legal system are unstable. They don't have phones. They're unhoused. You know, they may be struggling with substance use disorder. Mental illness. And so they're not fleeing prosecution. If, you know, you go out on the street, you could probably find them out there. You know, it's just they
suffer from something.
They're not able to keep track of their court dates.
I think there's a myth that like every person, I feel like it's a myth that every person who doesn't show up to court somehow has the mechanisms to free this prosecution, in the sense of like they got enough money to leave the state. Yeah. Like, I don't got enough money to leave New York. My license is in New York City. Yeah. I'll be a bum in Philly. Like, I don't got no money to be anywhere but here. I can't imagine my average client Now, obviously, in theory, if you have family somewhere else, but then even then, what life are you gonna have? You can't use your fucking social security number.
Yeah.
Like, it's like it's like
It's
maybe if you charge with murder, but
But still,
it's like.
And the data, that's actually a really
not
interesting
sustainable.
point because the data has consistently shown both nationally and locally in New York that the people charged with the most serious offenses are actually the ones that are most likely to return. It's folks who are charged with like the low-level misdemeanors and things that, you know, end up missing court. But like folks charged with most serious crimes, like they are consistently the cohort that comes to court, you know, most often. And it's like an inverse relationship with judges. Like they always want to set bail higher on people charged with the more serious offenses, even though those are the folks that are the most likely to not miss a court date.
Now, go ahead.
So you mentioned a few different types of bail, but are there others? I mean, we got partially secured, unsecured, insurance company bond, and cash.
They have non-monetary conditions too, like ROR. They have supervised release. A lot of clients they work with supervised release, so they get like supervised release. Make sure that they know when their court dates are. Give them type of resources, programming, and stuff like that. So like that's ran by CJA, right? Criminal Justice Agency, right?
Criminal Justice.
So yes.
Is the CJA everywhere?
In New York City, yeah.
I think different boroughs have different providers
For the supervised release
for the
program.
supervised release
Okay.
program. Yeah, I think different boroughs contract with different folks.
But CJA is in Queens.
Yeah, I think CJA is Queens. I think BJI, Brooklyn Justice Initiative, is Brooklyn. I think cases might be Manhattan. Yeah.
Okay.
But yeah, so like, there's those types of bonds. There's obviously, I don't think I explained the unsecured bond, but the unsecured bond is where you don't have to put any deposit down. You're just
gotta
You just got to promise that you're going to pay the full amount. Judges
never seen that
rarely
happen.
do that. I think I've heard of it happening in one case maybe. But obviously that's the most accessible because it doesn't require the family to have cash on hand right now to be able to post. And then, the non-monetary conditions that Bryant mentioned, whether it's supervised release, whether it's electronic monitoring, which is run through the sheriff's office. That's where you have to get the bracelet and like GPS track you.
Is that even available now, the electronic monitoring?
Yes.
Yeah.
Yes.
Yeah. What is the logistics? 'Cause I've got it done once, but that guy was out, and the judge was really mad. It was like, I don't know why you out, but I'm putting ankle monitor on you. So logistically, it was easy for him to go get it. But if you're in, like, what is the turnaround time on getting the ankle monitor?
It varies.
Yeah,
It varies?
it depends on like how understaffed the sheriff's office is at any given time. So sometimes they can do it really quickly and they have to actually go to Rikers to put it on. So like sometimes they're able to do that within a few days. Other times it takes weeks.
So people are placed into Rikers until the ankle monitor gets put on them, even though they're
Some of them are already
released?
detained. They're already detained.
But if I can say, he's saying if they get arraigned and the order is ankle monitor, it will take days to get it on them.
Because the sheriff have to check the person's where they're gonna live. They have to get this paperwork from the court, and then they do all their assessment to see if if this person's eligible for it. And then once they do that, they send the paperwork back to the court, and then the court judge signs off on it, and then.
Does it cost a defendant?
No, it doesn't cost
It doesn't cost any money, no. And then, so judges have the authority for like someone who, let's say they want to release the person, like let's say bail was set and then they decided to reduce it to electronic monitoring. They have the authority to release the person and let them self-report to the sheriff's office, which I think is somewhere out in Queens.
Yeah.
And then have the monitor put on there. So that's something that we frequently ask judges to do. Some judges will, let our clients just go to the sheriff's office themselves and get it placed on.
Yeah.
But other times they say no. And in those situations, if the person is, was previously at Rikers, then they have to wait until the sheriff can come to Rikers to put the monitor on.
Arielle, explain to them how, after a certain period of time, that like EM is like it's similar to being incarcerated. So that's like our last alternative too. But tell them how the time period takes for like you can modify that securing order?
Yeah, so the statute actually has it, and a lot of folks don't do this. So I hope that if there are any lawyers listening, you guys take notes. The statute says that the court has to consider lessening the restrictions. If they put somebody on electronic monitoring, and let's say they say, I'm putting you on electronic monitoring with house arrest. They have to revisit that determination within, I think the statute says 60 days. It's either 60 days or 90 days. I'm blanking on which one, but it's in CPL 51040 subdivision 3. And basically they have to lessen the restrictions if the person has been doing well on electronic monitoring and they, haven't gotten any violations and they've been doing what they're supposed to do. A lot of judges don't know that, and a lot of attorneys don't know that, so they don't ask for it.
They have to, or that they can?
They have to, must. It says must.
They have to consider. They have to consider it. They have to hear you, and they have to. If they're not going to do it, they have to justify why. So if somebody has been, doing everything they're supposed to be doing and complying with all that, it would be really hard for them to justify why they're going to keep them on house arrest.
I handle cases federally.
Yeah.
And federally, pretty much everybody gets an ankle monitor.
Really?
Oh, really?
Pretty much everybody.
Really?
You're either in jail or you're on an ankle monitor at home.
Yeah.
That's pretty much everybody in federal court. So the thing about it is, if you say to a judge, he's doing everything he's supposed to do on release, and I want you to consider lessening the conditions, the response is going to be, he's doing everything he's supposed to do on release because that's what he's supposed to do. That's not a reason to change his conditions.
Yeah, I mean, I can see judges say that, he's only doing what he's supposed to do because I have him on house arrest. But, I mean, the statute, the legislature, when they crafted that statute and put that provision in there, very clearly and explicitly, was signaling to judges that you should be lessening people's restrictions if they are doing what they're supposed to do, because the way the statute is set up is that judges are supposed to set the least restrictive means. So they changed the language a little bit. It no longer says least restrictive after the 2023 rollbacks. Now it says the kind and degree of control or restriction necessary, which means the same thing. As shorthand, I'm just going to keep saying least restrictive because it's just less words.
They obfuscated the language to make it more palatable.
To make it, yeah. But the whole point is that judges are only supposed to set those conditions which are absolutely necessary to get somebody to return to court, and the lessening of restrictions is supposed to be part of the process if somebody is doing what they're supposed to do, and they're showing themselves to be trustworthy and reliable, that suggests that they can do with some lesser restrictions. And so that's sort of the framework of the statute and the way it's supposed to work, that the legislature crafted it in 2020 for that purpose, to try to hopefully get less people entangled up in records, but also in these more restrictive types of non-monetary conditions like having to wear an ankle monitor.
Do you guys see unsecured bonds?
So almost all of them are unsecured. Mm-hmm. So the vast majority
I figure that.
So federally, what happens is we don't have arraignments until a case is indicted, right? And so there are, usually you get a phone call, and it's an FBI agent, and they're like, I want to arrest your client, produce him, or we're going to have a manhunt. And so, yeah. And so you go, okay, how long do I have? He goes, you can call the AUSA and ask them. So you call the AUSA.
What's AUSA?
It's the United States Attorney.
Oh, okay.
Right? And so you get on the phone with the AUSA, and they're like, hey, listen, bring him before noon, and we'll get him in, we'll get him processed, and we'll have his arraignment this afternoon.
Day of.
And
Daniel.
And usually the thing about it is FBI agents are pretty much not interested in doing anything on your time TV. And the reality is, unlike, if we complain a lot about the NYPD.
Yeah.
But the NYPD sees and they level with you. Mm-hmm. The feds do not. They don't give a damn about you or your cousin or your uncle or anyone else, or if anybody's on fire. That's the truth. And they don't have to, because the system is a juggernaut that wins almost every time. Mm-hmm. Right? So they know this. And they know the AUSAs also don't have to care about you or what you want. And so what ends up happening is you get you go to the presentment, and that's what we call a presentment, because it's a presentment of a complaint that goes to magistrate court. You're in front of a magistrate judge, not an Article 3 judge, not someone who is appointed by the president. Like, this is a magistrate who's appointed to the position usually by the administrative judges within the district court. And so you go in front of them and you make an argument for conditions of release. Usually they have pretrial services has done an interview. And pretrial services, it works with probation, is essentially like probation, and it's right there in the courthouse. And the funny thing is, federal defenders, institutional defenders in the federal system, federal defenders, that's what they're called, they consider themselves employees of the government. And they'll tell you that. They're like, I work for the government. So they all work together. They all have badges. They all come in and out of the back rooms. And so it's very weird, because when you go and you're an outsider like me, I'm a private attorney. I work for the client. Right? Like, I walk in, they're like, who are you? I'm like, I'm private. And they're like, I don't like this. Right?
Really?
Yeah, really. Look, a lot of people look. I have a different experience than I think some other people do when it comes to federal courts. I'm lucky. I've met a lot of good people who do a lot of the right things, and a lot of federal agents who are honest and do the right things as well. But until you can prove that you're not going to try to run and make them do the extra work, they don't have a reason to trust you. So I say that because you get to the presentment, and pretrial services makes a recommendation, and they usually recommend supervision. They recommend, all right, we want him on home detention, and we're going to give him a curfew for when he can work and when he has to. They don't want people to lose their jobs.
Yeah.
And that's the first standard, right? Like, they start off, and pretrial is a decent agency, right? Like, they really do try to help people, and if you do well on pretrial, they'll even advocate for programming for you that you can only get through pretrial services.
Wow.
Right? But if you don't do well on pretrial, you're going to MDC Brooklyn, which is been described as a hellhole by multiple Article 3 judges.
Yeah.
Right? But in general, you don't pay money to get out. You get a securing order, and the bond is usually signed by 2 or 3 suretors who have we call it moral suasion over, right? Someone who has, like, your mother, your wife, your best friend, people who you wouldn't want to see on the hook for a $250,000 bond if you don't come back to court. Keeping in mind it's the federal government, there's nowhere to run. You're not getting anywhere. So generally the courts know their power, and they use them effectively.
He'll get away.
So it's funny, because I'm surprised to hear you say that there are electronic monitoring actually being done, because my experience is that it's almost non-existent, and judges really don't like it, and they're perfectly comfortable issuing orders that are essentially pay $150,000 on your partially secured surety bond, or pay $50,000 on your insurance company bond, or pay $50,000 on your cash bond. And if you don't pay those things, you're welcome to get the sheriffs to secure you. But until they secure you, you're going to sit in Rikers Island. And we're going to send you to EMTC, and you're going to be around people who have various mental health issues, and you're going to feel very unsafe, even though you're an accountant. Right? Like, and that's a very scary reality. So one of the things that I find very shocking in our society is that you guys represent mostly indigent clients, right? That means that their families are mostly going to be indigent. Right? So advocating for partially secured surety bonds must be very difficult, especially given that people generally, maybe they work off the books, maybe they have very limited means, and my understanding is the courts have a cap on how many suretors are available. And we should explain, a suretor is the person who actually signs the promise for the bond, and the bond is the document that locks you into the commitment to pay if this person doesn't return to court. I know we haven't discussed that, but we want to make sure it's clear that those unusually large sounding words are really not as big as they sound.
And that's the person that needs to, if they're going to be a partially secured surety bond suretor, on the date that they come to court, they have to bring proof of income, which, depending on what borough you're in, at least in Queens, I always tell my clients, 2 to 3 months pay stubs and a W-2.
and this isn't written up anywhere, by the way. They don't have like there's not you don't call the clerk's office and they go, the list is this. They go, which judge set bail? And then the clerk has to essentially confirm with the judge's chambers what the settings are, which, by the way, they are not outlined.
That's the real shitty part about the process.
Yeah.
It's like, it took a while for it to get like distilled with due practice, what the fuck they want or don't want, or what qualifies or doesn't qualify. There's nothing worse than like, as a staff attorney that does criminal cases all the time, it's nothing worse than like sitting there going, what are you providing? You're providing this? How much you got? Okay, you're locked. And then to find out a judge just said, fuck it. Like, I'm not accepting that amount. Like, on what basis? Like, that's fucking insane.
You know, I'm also surprised to hear that you're uncomfortable with the bondsman, because the bondsmen don't have an upper limit on how many suretors they'll accept. If they can get enough people with enough money who will sign and make the commitment and produce the money, they will, and it's a lot smoother, it's a lot faster to get people out than trying to get the partial surety bonds. But I know you're an advocate, but my concern is if the choice is having somebody lose their job and not be able to, you know, especially if they're already indigent, they already make very little money, and they're not able to go home and they're in a jail cell, knowing that they're facing a crime that's probably going to be resolved without a jail sentence, even if it's a probation sentence, right? Because they, you know, the prosecution doesn't know that, but you might know that, right? I'm surprised to hear that. So what I wanted to ask is, how many suretors are you allowed to have, and what is the standard for getting that suretor approved by a court?
So you're talking about the partially secure bond, right?
Yeah.
So you can have...
Well, just in general, yes.
So I know you can have as many as you want. I think the more you have, the better, especially if they all have like the right income, the W-2 income. And, you know, especially if it's a high amount, you know, the most I ever helped somebody with was like $250, and they came with 25 cash, all different. And they didn't do double. They did like $300,000 total income, you know.
Nice. And then someone approved it?
Yeah, and it's just...
Thank you, Your Honor.
You are
the real,
by the way.
You are the real MVP.
Honestly,
whoever you were.
It was a judge, but it was a clerk too, because the clerks are the ones that are going to be reading your statements and stuff. So what I found especially when it first started, that really a lot of people in the court, they were just learning it like you. Yeah. So like if you're more versed in the law and you know what the law says as far as the partial surety bond on any part, most likely that gives you an advantage, because I've been in courtrooms where where attorneys, they went to me and was like, what's the total, what's the combined income? And I'll just say what it is, because I looked at all the documents before we went, and then the judge would take my word because nobody else is that versed in this law. So that's the advantage that you have.
Yeah, sometimes the paperwork is just pretty dense.
Is there somebody like you for
every
all
borough.
the indigent people?
Every
Because
borough, yeah.
I am constantly surprised. I call some people. Look, I'm a private attorney, but I do take free consultations. People call me on bail issues all the time, and not all of them have been contacted by someone.
How it's composed is like there's a paralegal case handler in every borough, and there's an attorney, a staff attorney that's in the decarceration project that deals with bail reform. And basically, we help in Queens. Danielle and I, we help all the attorneys, with bail issues, right? And so, anybody that like I tell clients, sometimes clients they get a stigma of public defenders, so they're like, yo, they ask me, should I get another attorney? And I was like, yo, listen, if you can get another attorney, but you're not gonna get the support like you get. Like nobody's gonna be you ain't gonna get people like Al, Sam and Jalen that's gonna treat your family like a human being and help them navigate that process and be creative and be like, all right, this is a roadblock, we're gonna find another way. You know what I mean? So
yeah, I feel like the stigma against public defenders is a volumes game, right? So like it's like a vocal minority where it's like if you're someone incarcerated, you're someone charged with a crime, and you have a bad experience with a public defender that maybe is overworked, jaded, needs to retire, whatever the reason is, that's gonna be the highlight of your fucking criminal defense career. I mean, criminal prosecution career, right? Like being prosecuted, but you're not like giving due all those other public defenders that treated you right or did a job well, right? Yeah, I feel like I tell clients all the time, like, look, if you want HEB, you want private, go for it, baby. But I'm nice. But it ain't no shirt off my back if you want to take one less case off my case.
My response to anybody who calls me and goes, I have a public defender, and that's the problem. I go, oh, that's not the problem. Problem isn't that you have legal aid, or that you have 18B, or you have a defender service. Problem is that you don't have an attorney you feel comfortable with. That's really the standard. And I think the bigger problem is more that you can't pick your attorney when you get court-appointed counsel. So you get stuck with whoever you get, and then you're in a situation where maybe that person doesn't feel, they don't credit what you're saying, or they don't trust you, or they don't have the time. Maybe they're fried, maybe they're going through something. The circumstances of a person, like I choose if I want to take the case. If I can't take it, I don't have time for it, I go, look, I'm sorry, I can't do it. I refer it to somebody else.
Yeah.
Right? But that's not a privilege that somebody like Eugene has. If he has 150 cases and somebody's like, well, here's 10 more, he's got to take them, and he doesn't get to say no. And especially if he's thinking to himself like, I have 7 trials this month, and there's no way I'm going to be able to give you the attention you deserve, and you need attention now, right?
Yeah.
And there's no
150 is insane. If I have 150, I won't be back in the ring. I'll tell my supervisor, hey, get me the fuck out of here.
Is that?
That's a big question. That's 90s numbers. You got case caps. We got case caps nowadays. Nowadays,
I didn't have a case cap when I was a prosecutor. Okay?
Nowadays, I can't speak for any other borough, but in Queens, we would love to be around 50 to 90, right? We would love to be in that range. Yeah. We would love to be 50 to 80. You start getting fried 90 plus, 120. 120, that next arraignment pick meeting comes, you getting less shifts. That's the benefit. I'm a artiste of my pick meetings. Like my pick meeting will come up, I have 120 the day after, it'll be like, I'll have like 80. I know exactly when my cases are 30-30, but all right. I feel like we've...
One thing I wanted to just add about the PS...
You can know. I might be fried today, but I won't be tomorrow.
About the Parsons Care bond thing is that, like, in case, like, if folks are watching who have tried this, like, don't get discouraged. So we frequently work with folks who they go in, the judge denies it because let's say they didn't have they didn't meet the income threshold. It's not a one shot like that's it, like one bite of the apple. You can always come back. Like if you need another, if you want to take some time to see if like grandma can come or a cousin that you didn't contact previously can help out. Like you can go back as many times as you need to make it work. Some folks though, like, they get denied the first time. They're like, this was a humiliating experience, which unfortunately for a lot of folks it is, because judges are not very nice and understanding to our clients' families and can be very demeaning. And they might decide, you know what, I know if I go to the bondsman, I'm gonna like lose some money, like they're gonna keep a fee, I'm not gonna get it back, but I would rather just do that and be done with it, and then have to come back and deal with this process again. So don't give up if you do get denied the first time.
Exactly.
Yeah. Well, I think that's the thing, right? Like a bondsman, right, can provide a degree of dignity to you, just like having an attorney advocate for you. Like there is something to be said for losing out on the $2,000 or $3,000 you're gonna lose out on, to know that it gets
Speak for
done.
yourself, homie. That's a lot of money. Well, I advocate for the broke. I ain't got no $2,000. I will be doing partially secured surety bond. It'll be Aunt and my wife figuring that shit out. And Mehdi seems like he's a good surety.
But this is what I'm talking about, right? Like people want their you want people out. Like this person is working. Maybe they have 2 jobs. Maybe they're under the table job. Maybe they're a waiter, right? They're gonna pick up shifts. They're gonna make their money. They're gonna pay it back. But they can't do that. And the longer they're sitting in a cell trying to figure out partially secured surety bond issues, and not to mention like bondsman can do your paperwork and get it in and be in front of a judge at even at like 12:45 p.m.
Yeah.
Whereas if you go in at 12:30 to do your surety bond with 10 signers, they're not gonna see you. You're coming back tomorrow.
Yeah, I mean, I think for some folks, like if the partially secured bond situation, like they know going in, like I don't have anyone who has the income, but like we do own our apartment and can use that as collateral. It may make sense for, you know, some families who are able to like kind of forfeit that fee to just do the bondsman process if it's easier and it's going to be quicker. The one thing I'll say about bondsmen, though, is that sometimes they add additional like conditions on someone that the court might just set bail and say like if you pay bond, like you go do what you want basically, just come back to court. That's the only condition. Bondsmen are allowed to set their own conditions, so they may say like if I pay this for this person, I want them to check in with me like every week and like do all that kind of stuff. And you know, some people may, you know, decide that like that is, these are not conditions imposed by the court, but if the client doesn't follow them, then the bondsman can revoke the bond. So there are those considerations as well. And so it's a very deeply like personal, individualized decision that like the posters, the people who are posting the bond have to make, the client has to make. And yeah, for some folks, I think the calculus may come out like where, you know, the partially secured bond process, the judges have made it so onerous that they decide, you know what, it's going to take 6 months for us to like get through this partially secured bond process because we need to find 5 more people to get the salary requirement. Whereas, you know, my grandma is willing to put up her apartment as collateral so we can do the bond, the private bond tomorrow, and so we're going to do that. So it's a deeply personal decision with lots of calculations, and so, you know, it's really up to the family and the folks who are posting, you know, which route they want to go. Yeah.
Is there any other? Have we covered them all?
I think we didn't cover the biggest one, most important
the
one.
rollbacks?
The most discrimination.
Oh,
Credit cards.
oh,
yeah. Yeah.
Right? So I was waiting to ask you about credit cards because I find that almost everyone, look, even lawyers, doctors, there's people, you know, things are expensive in New York City.
Yeah.
Pretty much everybody works check to check, job to job, task to task, right? So most people bridge the gap with a credit card.
yeah.
You have an arrest, unforeseen, ideally unforeseen,
Yeah.
right? Why is there such a huge refusal to accept credit cards?
I don't know. I mean, we have some credit card cases, and I mean, and then when you pay it, it's like they take small increments. Like you got to make all these transactions just to get $5,000 saved.
What do you mean?
Like
they won't charge you all at once.
Like 500 at a time or something like that. And
really? Why?
I don't know why the system
I think
is
their
set up like
system is
that.
very like antiquated, as is all, I feel like, government New York City
So, yeah.
government system.
Yeah.
Yeah.
So we had a client that had to do like 10 transactions just to make $5,000 cash on a credit card.
Wow.
So
That's wild.
But we don't see credit cards a lot, but it, you know, in instances that we do see it,
It's weird that like credit cards has to be because they're required to put 3.
Yeah.
It's wild that because they're required to put 3, even though they could put more than 3, as a defense attorney, I'm gambling by saying, hey, are you going to actually get the credit card, or should I keep partially secured as that third option? Because they might not accept both. Like it's one or the other. Like you're kind of arguing like one or the other way. It's like, look, they're going to pay 10%, but when they come, they might have a debit card, they might have a credit card. Like who the fuck knows what they're going to have? Like.
Yeah.
Like, why are you making it complicated? It should be automatic for both.
Exactly right. You can't use your debit card. So somebody gets bail set at 11 o'clock at night. Bank is closed.
Yeah.
Oh yeah, you can't.
Right?
You got it's straight hard cash.
Yeah,
Wait,
you
what?
gotta-
I
it's
guess
like-
what other forms?
It's cash.
Money
Some
order?
courts accept money order. But yeah, it's basically cash or money order, depending on the court. Cash is accepted everywhere. Money order is only certain courts.
But that's at arraignments, right? Because once they're in Rikers, I feel like every time I look up my client on inmate lookup, it's like pay the bail, and it's like a little button you can press. I don't know what that button
Yeah,
is.
so it's that has been down for the past few months. I'm actually not sure if it's back. DOC told us that they were updating their system because you used to be able to pay online.
I'm assuming online is the debit card.
Yeah, but they said they were switching systems or switching providers, so they took it down. I'm not sure if it's back yet.
And when it was up, if you could use a debit card, could you also use a credit card, or you couldn't use a credit card?
That's usually a court order. Like that's part of the court securing order.
The credit card, you have to actually have the judge mark it as like credit card allowed.
That's one of the things, right? Like a judge has to do it, and you can ask. They won't allow you to pay the cash bill with your credit card or your debit card. People don't have cash on them.
Yeah.
You know what they have? They have their debit card.
Yeah.
And you set $1,000 cash bill, $2,500 cash bill. Somebody might have that, even if they are indigent, but they might be good at saving their money.
Yeah.
Maybe they got paid that day. Yeah. They haven't paid their rent yet, right?
Yeah.
Like,
but yeah,
I mean, you're gonna send them to jail rather than let them swipe their card.
I mean, when I first, like in 2019, when I first got to the decarceration project, there was a client. He had saved up like a substantial amount of money, and his bail was a certain amount. And so what I did was I went to his bank, got their what is gives you permission to power of attorney.
Power of attorney, yeah.
So I got the document from them. I asked their manager what's the process. He was like, all you gotta do is get it filled out, get it signed by the client, and we were able to. He gave it to like a family friend that he was living with, and we talking about like a substantial amount of money, like $30,000, and they did what they had to do.
What's crazy to me is that I find insane is that you need friends to get out of jail.
Yeah.
That's
Friends or family.
Crazy
Friends or family.
ass reality that we live in, where it's like you,
spouse,
like if you got, let's say you got money and you got no one that loves you, but you got money, like once you're in, you can't just swipe it on the inside or do like a transaction. Like, hey, let me just log into my Citibank. What's your like routing number? Like, I will send it to you. Like, you can't do that. That's
you need people to
insane.
make moves.
Well, this has happened, right? So when I do a surrender, right? Most of my arraignments happen when detectives call somebody and I have to arrange a surrender, and we go in the morning, and usually my clients give me their stuff because I'll be meeting them that afternoon to get them out. One time I go to a surrender and the DA's office asked for bail, and we had this judge who set bail. The case was, and I told the judge, I was like, Judge, there's no evidence, I have proof that this didn't happen. Judge didn't care, set bail.
This is federal or criminal?
Criminal, state. This is state. It's Kings County. It's 12:30 at night. They're about to close the court. I go, Judge, no problem. They set the bail. I said, can we have a credit card alternative? They said, okay, sure. I go, great. The guy had a credit card. The credit card was $3,500. I said, he can pay it right now. I have his card. Can he go pay? And he goes, no. Somebody has to come and pay it with a credit card for him.
Yeah.
They wouldn't let the man swipe his card at the window.
It's fucking disgusting.
They refused to escort him to the window to swipe his card.
Yeah.
And so I had to call his mother in the middle of the night, ask her if she could rush before the court closed to swipe the card. He had to spend the night in jail because they wouldn't let him swipe a credit card.
Did she end up swiping his card or her card?
She had to swipe her card.
Her card.
I don't have power to. I don't have time to actually.
Yeah, you gotta do all that.
Right there. They're not going to accept the credit card from me, even with his permission. Even with him in court, I was like, Judge, can I? Since he's standing right here and I'm here and I have his credit card, can he tell you that it's okay for me to swipe his card? No.
But that gets dicey because a lot of times, like, even with that big amount of money, they wanted me to handle it. But as a public defender, I would be reluctant to handle anybody's money or credit card.
I'm talking about permission on the court record and the court transcript.
Yeah,
Not talking about
I get
like me having a conversation on the side and swiping.
I'm going to H&M real fast. I'll be back.
You don't.
But I guess.
So
what is that? Because like this is all practice, right? Like this is like cracks in the system. Because you would think, yeah, I'm arrested. I don't know nobody. Fucking like whatever. Like fucking my family died in a car. I don't fucking know. I don't know nobody.
Yeah.
Like why do I have to not? Why can't I pay? Like it's a bail. It's on my life. Why can't I use my own money to get out? Like is that just? Is it purely, like, is there anything in the statute, like, kind of addressing it, or is it purely just practice, and can that be fixed?
Yeah, I mean, so there is like, for bonds, there is a special type of bond called an appearance bond, where that is basically, instead of a suretor, like a family member being the suretor, it's like you are your own suretor. Okay. So like for appearance bonds, that's a thing. But for cash bail, like there's no reason in the statute why somebody couldn't pay their own cash bail. It's called bail regardless of who pays it. It's not like surety bond versus appearance bond where like it depends on who's paying it. Like cash bail is just cash bail. So I mean, yeah, that feels very much like just OCA, DOC, like issue with like not wanting to transport people or escort people to bail windows, something that very easily is fixed. Yeah,
that's just disgusting. The one good thing about being in the criminal justice system is that I know America could never be just taken over by America.
Yeah.
like NYPD don't get along with the fucking corrections officers. Like, how the fuck are you guys gonna hydra up this country? Like, it is not happening. Like, you guys don't have the like unity. Like, you guys don't have the will or the desire to work.
Yeah.
All these like steps that have to work together, y'all not doing it.
Yeah.
Like, this shit would turn into militias real fast.
Yeah. They were still using fax, like we're still requiring fax things to like security orders to be faxed like up until very recently, and it's like, who uses fax machines in 2020?
If you live in New York City, clerk's offices won't leave email, and they don't all use EDDS, and they require personal service. So they require personal service and they require faxes. So I literally have to have a fax machine account solely for the fact that I might have to go upstate.
Yeah.
And for a long time, even like the magistrate courts in the Eastern District of New York and Southern District of New York, I couldn't email them my notices. I would have to fax them because you can't file them.
When you fax it,
public
you're doing like an email fax, right?
Yeah.
Oh, okay. You're not like throwing it through the machine.
No. I have to have this fax system solely for this.
Yeah. You got to pay a fee for that.
Yeah.
And so it's a very funny thing because it's still a real issue.
Yeah.
And there is this, I think it's a misnomer, right? That this idea that faxes are more secure. But since we do them electronically now, they have the exact same effect as an email. It makes no sense.
So what I want to know is, right, I do, because I have like, my job provides me with that fax ability. Are they getting it on their fax email, or is it coming to a machine?
So it depends.
Because it sounds like we just emailing each other, homie. Like, if I'm using a digital fax and you're using a digital fax, it sounds like we're emailing each other. So am I fucking?
When I was in the DA's office, I was getting a digital fax. It showed up in the thing. I popped it open. It was a group. Everybody had the same faxes. If you didn't get it quickly enough, you had to go through everybody's faxes, which is really not secure, right?
Yeah.
Like paper. You mean paper?
Yeah.
Or paper?
No. I mean like the fax mailbox on our portal.
Oh, so there was a mailbox, digital mailbox.
So just like you get a fax and you get and you go in, there's a log of all the faxes. It's the same thing. So like if you were in, for example, if you were in early case assessment complaint room ECAP, you got the fax, it went there, and you had to go get it. And if you didn't get it fast enough, you had 10 other new faxes, and you had to figure out which one was yours. And and the number is the same number for the precinct, right?
Yeah.
So now I fax to the courts, and some courts they're 100% looking at it in like a digital mailbox.
Yeah.
But some of them are like, let me check the fax machine.
Yeah. I was gonna say DOC still deals with paper. Like there are a lot of their stuff they have to have in paper. Like they're like, oh, the paper, the card, the physical card didn't make it to this person's desk, so we can't do anything.
Yeah. It's weird though, 'cause they might be ahead of the curve because Microsoft went down.
Yeah.
You like paper now, motherfucker? Like, you like paper now? I was telling my wife, nah, they got shit on paper. I gotta go to work.
Yeah.
Like, my job didn't stop because Microsoft went down. I don't think.
You know, I gotta tell you, I got a call from the clerk's office that Friday, and they were like, "Don't come.
Really?
Don't come. Nothing works. You can't even pay anything." Like, so they wouldn't accept payments. So, like, if you were trying to post bond last Friday when Microsoft went down,
Really? That's fun.
it's very possible your family member, your loved one, had to sit there because they weren't accepting any money from you.
Check out the civil rights litigation lawsuit, and that sounds like some money for you. Check it out.
Yeah, I was gonna say NYPD, like they weren't bringing people to arraignments because like their systems were down, so people were waiting longer than 24 hours to get arraigned. Yeah.
Do you remember that happened during COVID?
Yeah.
They had it was like an electric power issue because there wasn't enough people working to maintain the grid. So they lost electricity in central booking, in several central bookings in the city of New York in the summer of 2020. And I was back at work by July. Like everybody else was not working
Yeah.
for a long time. Not me. July, I was back to work. Literally, they were making me appear in court.
Wow.
So I remember this, and I remember.
I was in Miami.
So I'm getting this. I have a client who's sitting in the precinct. He sat there for 2 days on like a DWI case because they couldn't bring him to central booking because everything was messed up. And I remember this, and I was thinking to myself, like, what happened in these situations? And there's no chance he's getting bail. Not bail eligible. They could have given him a DAT. They do it in every other part of the state of New York.
Yeah.
But the city of New York was like, no. You got to sit here and wait for 48 hours that you never needed to be in custody.
Because the city of New York don't give a fuck.
So from your perspective, getting back to bail reform, how do we fix these things? Right? Like these are ridiculous issues. And I think that's the whole point, right? The whole point of this Reform Act is like, even the federal government doesn't do this to people.
Yeah.
With all their power and the fact that the case they have, they're going to ask for prison anyway.
Yeah.
They're going to ask for prison. They still don't do this to people. So how do we fix this?
Yeah, I mean, I think a lot of it is like shifting the narrative and shifting the culture. I mean, obviously we have the elected leaders that we have in New York State and in the city, and they have a very anti-bail reform, very carceral view of like the criminal legal system broadly. And so it's really, I think, on us in terms of like the regular everyday folks, like the people who they're supposed to represent, to like advocate and care about these issues. I do think that there's a lot of room for public education, because we see this every time they attempt to roll back bail reform, or you go interview folks on the street and they're like, oh, like they'll say things that are just completely not true under the law. It's like, oh, they can't lock anyone up, nobody's eligible for bail anymore. It's like that's not true.
That's a great segue, because you kind of buried the lead, because this conversation is so like there's so many ways to like go about it, and it's so important information. But what's qualifying, what's not qualifying, and for the people that don't understand, guns are qualifying.
Yeah.
Like violent crimes are qualifying. But so like break down the qualifying, not qualifying.
Yeah, I mean, you pretty much said it. So like most violent felonies are qualifying, which means they're eligible for bail.
Well, not just violent ones, right? Because there's also anything that's labeled a domestic violence crime.
Yeah,
right?
so there's some misdemeanors too. So yeah, most violent felonies are, I think, with the exception of one type of robbery. And then most misdemeanors are not bail eligible, except for like certain sex offenses, certain domestic violence offenses, certain things that are labeled as hate crimes. And then most non-violent felonies are also not bail eligible. So if you want to paint with broad brush strokes, it's like violent felonies and like misdemeanor sex offenses, misdemeanor domestic violence, hate crimes. Those things are generally going to be bail eligible, and like everything else is generally not bail eligible on the first go round. But that's the other thing people don't understand, is a lot of people are like, oh, it's just like a revolving door. There are different provisions in the bail statute that allow judges to set bail even on non-qualifying offenses if, for instance, in certain situations, if the person gets rearrested for a certain offense, even though it's not bail eligible, if they have, if they were out on a previous offense at the time they got rearrested, in certain cases that can make it bail eligible. If the person is out on a non-bail eligible offense and they're accused of like intimidating a witness or violating an order of protection, or they willfully and persistently don't come to court, like those things can turn non-bail eligible offenses into bail eligible offenses. So it's not even as like clear cut as just this is bail eligible, this is not. There's a lot of overlap in terms of, even for the non-bail eligible offenses, certain triggering things can happen that make it bail eligible.
And a lot of these were part of the original statute, and then most of them are part of the rollbacks.
Yeah.
That's rollback.
Before we get to the rollbacks, we're going to do a new segment on Attorneys with Swag. This is I'm going to try my best to get this, a PAWSA, Public Attorneys with Swag announcement. And on this PAWSA, I'm looking directly at you, family member or friend. Pay your friend's bail. Pay your family member's bail. As a public defender, you used to be a prosecutor, and you would know this. Your case got a lot worse if your client was not incarcerated. my client gets a lot better if my client's not incarcerated. There's a lot of leverage. There's a lot of leverage to not being in jail. One, you can get into a program, and what I tell my clients is that if you're not in jail and you have a really shitty case, what you better do is build what I call a resume of good behavior. This is, you committed a crime allegedly, probably you did it, or probably you did whatever. This guy wants jail time, and the only way we're not going to get jail time is by giving him a resume of good behavior. You did a program, you got a job, I know someone that's about to join the military. You do what you got to do to have a resume of good behavior, and you cannot do that while incarcerated. I mean, in theory, you can get your GED and do a bunch of things in Rikers, but I don't think that really holds that much sway to a prosecutor. And for that reason, assuming you want your friend, your family member, your husband to get the best disposition in their criminal case, you should go through all these hoops that we're talking about and help them get bailed out. What do you think?
I do agree that you should help your family. Look, the truth of the matter is, bail is not supposed to be a punishment. It's just so that the wheels keep turning in this system of alleged justice that we have, right? And the only way it works is if we treat it properly. The first thing is, people have to have an opportunity to be heard in court. They can't be heard in court if they don't come back to court. That's why they make all these rules. But the truth of the matter is, and the most important thing they need to know is, bail is not a punishment. And if somebody is demanding bail on a case where they don't even want jail time, that to me is a fundamental kind of harm. Truthfully.
That was a lot.
Additionally, and this is really, really important, right? We shouldn't be using detention as a way to force people to admit guilt to crimes they didn't commit, or maybe that they have defenses to, right? People, if you ask for bail, you put somebody in the cell, and then you come back in 6 days later and say, oh, I want 5 days jail time or a time served sentence, that is fundamental corruption. Clear as that, right? And I think that everybody here would agree that if you're putting somebody in custody, that goes on an expedited schedule. Can't be on the same schedule as everything else going on in the courthouse, right? When the case is not on, or doesn't have bail, that person should have more time. The DA's office doesn't have to see that case next week. But if you're in custody and the DA's office meets certain burdens, right? One of the big ones is if you have a misdemeanor, you have what's called a 170-70 date, which is a date in which you have to convert the charges. You have to provide a supporting deposition. You don't have to be ready for trial. You have to cure the hearsay. That means the allegations that you cannot confirm through direct statements of a witness. If you have a case that's a felony, you have to get it indicted within 145 or 125 hours, depending on the time in which the case starts. If you do that, then the person's going to be staying in. But that doesn't mean they should be sitting there for months while the DA's office spins their wheels. That's not fair. Get the discovery out ASAP and get that case in front of a judge 2 weeks, 3 weeks maximum. And that's what needs to happen, because people need to be seeing the judge and need to be hearing what's going on in their cases. That's why people feel like the system is so unfair, because they're not seeing the information that's being held indefinitely.
And more importantly, pay that fucking bail. Help them out. Try your best. PAWSA. All right, now back. Sorry, this is really, it's hard to say that, but all right, back to it. So, like we said, violent crimes, qualifying offenses, which means, simply put, judges can set bail. New York City has now become a fucking lawless, like, Westworld, where you can just fucking commit any violent crime you want and get out. But unfortunately, that was the perception that did take hold after the 2020 bail reform, and because of that, there's been several rollbacks. And you did kind of go over them very quickly, but what were the rollbacks, and like what exactly were they perceiving? What were they like addressing, and how did they come about?
Yeah. Basically, it was like politicians and people were saying that there was more crime, and there's no correlation between the bail policies and increasing crime or whatever. And like another thing, another thing that they added too was like if you are a persistent felony offender, that you're bail eligible, or if you're on parole. So those two things as well. But so that's where it all came about. So when they changed, so that the
when was the first rollback?
The harm on harm in 2020.
So the statute went into effect in January of 2020, and by that spring they'd already rolled it back. So they'd already been talking about rolling back before it had even been in effect for like 6 months. They didn't even give it a chance to like start being implemented before they did the first round of rollbacks.
We were in lockdown during half the time that they claimed crime was increasing. Nobody was outside. There was no crime. It's not true.
Yeah, people were. Yeah.
I won't lie. I could see the bloodlust in their eyes.
Yeah.
I was like, you guys miss it. I can tell.
Yeah.
Like, you need your fix.
So the first round they added some more qualifying offenses.
That's the first round.
Yeah, the first round.
When did harm plus harm? Because that's a big one, and I feel like that's the one we should break down.
Yeah. So they added harm plus harm, I believe, in I think they might have initially added it in 2020, but then they amended it in 2022 to make it even broader than it was in 2020. Yeah. And harm plus harm is probably the most devastating rollback that we've had in terms of facilitating more people going to jail, because what harm plus harm did was basically say if you are out on a Class A misdemeanor or a felony that caused harm to an identifiable person or property, and you get rearrested for a second Class A misdemeanor or felony that caused harm to identifiable person or property, then even though neither of those offenses are bail eligible, they become bail eligible. And they tried to do this thing where they said, except if it's like negligible theft, then, we won't put you in jail. But judges interpret negligible theft really broadly. So we've seen clients who are unhoused and they get...
In the statute, it says except negligible theft.
They
use negligible theft as harm all the time.
Yeah, they do. Yeah, like we frequently have clients who are unhoused and they might, take a bar of soap from the Rite Aid and then get released because that's not bail eligible, and then a week later they're going to a different Rite Aid and taking toothpaste, and obviously those things are very negligible, but courts will routinely find that it's not.
And what's more nefarious about it is that it's harm, right? So it's like when you think of harm, you imagine violence. You imagine at least a physical kind of like
physical harm. Yeah.
Physical harm, even if it's not, if it's financial harm, right?
Yeah.
Let's assume it's financial harm. It's a real financial harm. You
Yeah.
lost something. And you'll have like a petty larceny case.
Yeah.
In which they get arrested right out the store.
Yeah.
And the items get brought right back.
Yeah.
So what you're basically saying is this client allegedly inconvenienced these people.
Yeah.
And that's enough to activate this statute, which is fucking insane.
Yeah, and we make that argument all the time. It's like he got caught before he even left the store. They didn't actually lose the soda that was in his bag. And they're like, nope, that's harm to the multi-billion-dollar corporation that they had to hire somebody to to take the soda and put it back on the shelf. So now this person's going to Rikers. That's been probably the most detrimental and also the most just completely disregarded part of the statute, that negligible theft piece. And we've seen judges say self-harm is harm. So some judges have tried to make the argument that if the client was arrested for drug possession, that they're harming themselves by using drugs.
I've never heard that shit.
Yeah.
That's crazy.
Yeah. Or
that is absolutely out of
That's crazy.
That is.
And show me what study says Molly harms you.
Yeah.
Right? That doesn't sound accurate, does it? Show me what study says that.
So they interpret harm very broadly, even drug sales, obviously possession and or sale of a controlled substance are not bail eligible, but judges will say, well, you're harming the community. So we're going to set bail. So yeah.
And so when that happens, how do you fight back?
Yeah, so usually, I mean, so harm plus harm is a really hard statute to actually writ because usually in these cases, the bail is low enough that it's payable, and so we don't actually get a chance to writ it because it moots out by the time the writ is filed and decided. Ideally, though, in cases where the person's not, getting released soon after, then we would file writs of habeas corpus for these folks and
explain that
mitigate
process.
Yeah, so a writ of habeas corpus is basically a filing that says somebody's being illegally detained by whoever. So in New York City, we say that Department of Corrections is illegally detaining our client. And it's a mechanism it's an emergency application, so we're able to get in front of the court pretty quickly. And we have to...
Which court? Is it a specific court?
So we can file them both in local trial court, Supreme Court, but also in the appellate division. So in different boroughs, we do things differently. Some boroughs we generally file in Supreme Court, and then other boroughs we might go straight to the appellate division because the Supreme Court judges just are not it's not worth our client's time to do it at Supreme Court. I mean, in every jurisdiction it's really hard to win writs. And I would say even in appellate courts it's really hard to win writs.
I've done a few writs, and I feel like this is a very complicated, onerous process, and it doesn't seem like you give a fuck.
Yeah.
Not even a little bit.
Yeah.
What is a writ?
You're filing a writ of habeas corpus, which is basically... She said it better than me.
All right, would you like to explain?
Yeah.
I don't think. Look, it's a Latin word that means nothing to the average viewer.
Yeah,
so
I mean habeas. I think habeas means, I think Bryant said free the body. Corpus is body. Habeas might be free. I don't speak Latin. I think that's what
habeas is free. Corpus is body.
Yeah.
Writ is what?
And so, a writ is basically you are asking the court to free your client's body. And the way that you kind of have to argue it is you have to say that your client is illegally detained by virtue of some abuse of discretion by the judge who determined that they would be detained. So like in the harm plus harm context, for a judge who set bail under harm plus harm because they said our client's use of, whatever was self-harm, we would argue in our writ of habeas corpus that that person's illegally detained because the offense is not bail eligible because the judge abused their discretion in finding that self-harm was harm under the statute.
Is there a statutory or a case law? Like under what power, what law are you able to make this argument?
Yeah, I mean, so writs of habeas corpus are actually civil filings, so they are part of the CPLR. So writs are civil proceedings. Article 70. But when we're the arguments that we make in the writs are based on the bail statute. So we can file a writ and just arguing that the bail is excessive. We can say, this was beyond what was necessary to ensure our client's return to court, and so the judge abused their discretion in setting it this high. And for those arguments, we rely on the bail statute that says the purpose of bail is to ensure return to court, and it can't be more than necessary. If we're challenging if we're saying a judge didn't follow a particular part of the statute, like harm plus harm, or if it was one of the modification statutes where the law says the judge has to have a hearing before revoking our client's bail, and the judge refused to hold a hearing, we would rely on that part of the bail statute saying the law says they have to hold a hearing, and it was an abuse of discretion not to. That's generally how it works. And then the judge who's hearing the writ has to decide whether they think the previous judge abused their discretion or not, which is a hard thing to ask judges to do because judges don't like to find that their colleagues.
And I feel like it's especially hard to do it in the same building.
In the same building, that's part of the reason.
Saying, I'm one judge and I'm saying fuck this other judge.
That's a huge reason why we like to go to the
saying. I mean, a lot of think that's what they're saying.
Well, that's not what they're saying, but I think the reason why they don't do it is because they don't want it to be perceived that's what they're saying.
You know what I find unusual? So now the habeas corpus, it doesn't just pertain to bail statutes. Like like I've won a habeas corpus when I was away, right? I did a remember when they were sentencing people when they started post-release supervision? In some instances, the judges, they were just saying you have a flat 5, but they failed to give them the post-release supervision. So you had people going upstate with just the flat, not the. And when you look at their commitment and sentencing commitment papers, and you look at their sentencing minutes, it shows that the judge only sentenced them to the flat, not the post-release. So you had the phenomenon of guys actually finishing their flat bid, and then the Department of Corrections, New York State Department of Corrections, imposing post-release supervision when the judge didn't. So there was this guy, he had several violations for parole he didn't have, post-release supervision he didn't have.
Oh, wow.
And I did his habeas corpus. And there's a statute, there's a case in the Supreme Court that says the only one that can sentence someone is a judge, not anyone else. And, you know, they had to send him home. So habeas corpus could be used for, you know, other legal issues. It's a civil proceeding, like Arielle said, but it could be used for any type of criminal law.
Yeah, I feel like my history major is failing me, and I know it's really sad, but I know habeas corpus has like a revolutionary like context where it's like they were like that's why we went to war, because they were like confining people and taking their liberty away without any due process, without any kind of like.
It's in the Constitution, I think it is.
Yeah, it's in the Constitution because it's like that's like the most important thing. Where it's like
the Sixth Amendment right. It's our rights of habeas corpus are the statutory embodiment of your Sixth Amendment right to freedom, to not be withheld without due process of law.
Exactly. See, you recovered. You helped me recover.
So what Arielle and Bryant do essentially with the bail reform is they are fighting using a statute that we now have that's really special, really important, to embody our rights to be free. Like we have the right not to be detained unreasonably, and that's
especially
our Constitution,
pre-trial.
right?
Especially pre-trial.
Yeah, exactly. That's our Constitution, and we wouldn't have a Constitution. We wouldn't have a nation if the founding fathers didn't agree to the Sixth Amendment as part of the Bill of Rights. And the 14th Amendment made this particular amendment embodied within our states' rights, and it is something that is embodied within our Constitution in New York State, as well as within this new law and within Article 70, right? And so what they're doing is they're upholding the truest aspect of our civil rights, which is really special. I want to ask you, Bryant, about you said you went upstate and you had to litigate for yourself.
Yeah, and all this.
Can you tell us about what that's like? What is it like to have to litigate for yourself?
So it's like you got legal training from institutions, but I had to learn to defend myself, like, you know, because I was wrongfully convicted also, right? So, you know, that's all. That was part of my to keep the time going by, to learn as much about the law as I could. And as I started learning and as I started going to parole boards, getting hit several times, then I said, you know what, let me do my own parole appeal. So
what does getting hit mean?
It means to get denied parole, and they assess you 2-year holds every time, right? So I went to 5 parole boards, right? I went to 6 parole boards, and I got released at the 6th one, but I got denied 5 times, right? So I spent roughly 10 years past my minimum, right? Damn. And so that was my desire to learn law. So as I was doing my parole appeal, you know, other prisoners were like, "Could you do my work?" And I was like, "Bet." And then I did.
Yes, bet.
So I was doing my parole appeal. I did someone else's. They was challenging. They got denied temporary release, and then the other guy, his Hague for the sentencing. So this is 3 different areas of law, and that was my first time really even filing anything. So I did 2 78s and a Hague all simultaneously, and
when you're doing it for
you
them,
say 78, you mean Article 78?
Yeah.
Right. And can you explain what that is?
So Article 78 is a proceeding to challenge administrative decision. So a parole hearing is an administrative decision. Like if you supposedly your kid gets suspended from school, that's an administrative hearing. So you could do a 78. So I did it from research, and they didn't have no legal digest, no legal database. You got to go in the library. You got to get that digest, find the subject, find the cases, all that.
I don't want to do that.
But you find it better like that. You know what I'm saying? Because you read the case, then you find the case that you're going to use. Sometimes, like when I did the challenging the temporary release denial, there was no cases. So just the statute. And I filed it. It was the same judge of some upstate county.
So when you're filing it for the benefit of one of your some people you're in jail with, are you able to put your name on it, or are you doing it in jail?
I do underground. So I have my typewriter in the day room. Typewriter. It's like my office. I had it on the table. Okay. And guys are sitting there. One guy, he didn't speak English, so I have another prisoner interpreting. Wow. And that's the guy with the articles, the temporary release. He got caught with he got charged and convicted with a kilo of cocaine, and a lot of guys were like, yo, he's not going to get temporary release. They're not going to let him go. They let him go. And, I did his work. And
that's fucking God's work, bro.
Look, back to back.
God's work,
the first one was his. It came back in the mail. He gave it to me to read. And it was like, he won the decision in order. I was like, you going home. And I gave it to him. And then the second one was the guy with the Habe. Yo, you going home. And then mine came back last. And it was just, with parole, they just give you a new hearing. So they gave me a new hearing. So instead of 2 years, they sent me back within that 1 year. So that's why I got 6 boards. You know what I'm saying? Because they gave me an extra one. But that was that's when I knew that, like, public interest was for me. But all I wanted to do was be a paralegal. And then, so I just kept helping people. And it was like, I was winning. I was like I wasn't taking no L's. I was like, high 90%.
How many did you end up doing?
I was doing a lot of, I was winning at the administrative level. You know what I'm saying? Like I was winning a lot of temporary release appeals, a lot of, I was doing the parole appeals still. I was winning 78s. I was just kept on doing all types of immigration, family court stuff, like all types of, so that's why, like, that's how I learned law. Like I learned, like, you know how some lawyer, like in our firm, you got staff attorneys and they just do from pre-trial, right, to conviction or whatever disposition. But the way I learned it is like, even though we started in the trial part, I also did I went to the appellate division with you and all that. Like I did all that. So I was like, but it was just incredible, man. I was like, wow. Like I knew it wasn't a fluke. I was like, this is not a fluke. Like to win 3 things back to back your first time, like to really, it was amazing. And then just kept winning, and it was just amazing.
So, would you say that in your experience, having gone through this, having been in the jail, right, and having to talk to this prison, right,
Facts.
Having been through the experience and seeing people who had no idea what to do.
Yeah, it's rough because like you have, it's rough. Like I was able to stay away from like I didn't want to perpetuate my own oppression, so. I stayed away from all the prison vices, and I was able to make safe spaces for people that, that couldn't really, what I'm saying? So, like, if you was in a housing unit with me, you lived because, I just was like that, right? So, I ran into, you got guys that, the young kids, like, I seen generations change. So, when I came into prison, I was 20 years old, and the oldest number was a 70 number, right? So my number was like a 93 number, 93A 4410. So you have these guys with 70 numbers, right? And then fast forward when we get into the 2000s, like 2008, 2005, that 93 number is like one of the oldest numbers. You know what I'm saying? So I'm dealing with different generations, but I'm able to navigate that because, I could connect with them on a human level and I'm authentic and, you know what I'm saying? And that just carries on more. That's how I was able to to really grow in a very impressive environment where most you see our clients, most of them don't do well, So when you're encountering these guys that's in these prison vices, like they might be involved with gangs, drugs, whatever, and when they get into trouble, who are they going to come to? They're going to come see me. But they're doing all this, and I think guys that were sentenced to life under the drug statutes, but because of their behavior in prison, when they changed the Rockefeller law, they were unable to go home or get the life taken off because of their prison record.
Really?
You know what I'm saying? So I was telling you, look, you in here playing around, you could be in the streets because they just reformed the Rockefeller law. But
So you were in there in 2008 when the law came.
Yeah, all the way from I got 1992 all the way to 2011. Only been out in the streets 13 years. Wow. I was able to, when I came home to abject poverty. I was living in a rented room, and the poorest section in the Bronx. I had to.
You mean the Bronx?
You're talking about over there, Prospect Avenue, the poorest section of the Bronx. I had to. I built up a lot of discipline. I had plans, but sometimes when you come out and you're going from one adversity to another one. So I think prison allowed me to successfully go from one adversity successfully. So when I came home, I was just like, I was a little I was like, dang, wow, I still got it's still a struggle, but I was like, you know what? I stayed focused to my purpose. My purpose was just to get a job, get into college, and I just kept on grinding. It was hard, I was working the Hunts Point Market. Like, some of those conditions were worse than prison conditions were, you know what I'm saying? Like 40 plus hour work weeks, I was fortunate. I met my wife in City College and got married. So I had to do all these things. The pressure of you can never catch up, but you feel like you got to catch up, and you got to do all these. You got to re-enter society. You want to have a family. You want to have a career. You want to do all these things. You got to do all these things together. And sometimes that's a lot for a lot of people. You know what I mean? So, but I was, by the grace of God, I was able to do it. So, it's just been a rough journey, but
So, considering the astronomical growth and development and goodwill you've conducted, have you considered applying for a clemency petition?
Actually, I'm still trying to get my case overturned. So I've been working. I've just been working on it. I'm waiting for the DA to send me their case file and all that, and I'm gonna go. I'm gonna start from there. So it's I'm working on it.
All right. And what would be your advice to people who are facing this, right? Other than read what you're dealing with.
So when I was in Albany doing some parole advocacy, and then there was a guy he was speaking in front of a press conference, and he was talking about how difficult it was. He was sleeping on his mother's couch, and this is a guy that did like 30, 40 years, and he's much older than me. I was released at 39, like the end of my prime, you know what I'm saying? So I understand the struggle, but I also understand that. So after he spoke, I just talked to him. I said, "Oh, listen, man. I told him, that I have a similar experience, and I told him that, listen, reentry is like a lifelong thing. You know what I'm saying? So, I'm at a different phase. Like I've been in the streets for 13 years, so I'm at a different stage of my reentry than you are. And I was like, just keep doing what you're doing. Things are gonna get better for you. You're gonna get opportunities. You know what I'm saying? So just to say that, and then he's like, thank you, and just to say that to somebody that's going through it. So I know that will help him, because he'll be like, that'll inspire him and be like, it gives him light. Like, if he could do it, I could do it.
Yeah, facts. Like you gotta grind, man. It's like anything else in life. Obviously, it's a much more difficult grind than the average person has to go through. But like everything else, you just gotta work on it one day at a time.
And it's just it's like if you met me when I first was released, I was so hungry. It was like and I think and like just trying to do so much. there's been times like burnout, like, you know what I'm saying, literal burnout, like especially in undergrad, like working full time and undergrad at the same time, like doing all that. So, you know, I would advise people to like, you know, just don't try to play catch up. Just, you know, just do the best you can, and you know, don't burn yourself out. You know what I mean? Just try to, you know, live a full life as you can. You know what I mean?
So, with your perspective, you're seeing all these bail decisions, all these people getting sent into custody, sitting there struggling to get out, family can't afford it. You have a unique perspective because you work in the system. You see these judges, you see these attorneys. Do you feel like they just don't understand what they're putting people through when they make these requests for unreasonable bail?
In some instances, but I don't take it too personal. My thing is just like exhaust your remedies until you don't have anymore. Like, you know what I'm saying? Never give up on a case. You know, the unit that we work with, like the lawyers are awesome. Like, you know, we got some killers, you know what I'm saying? That they'll exhaust it all the way as far as it can go, you know. And you know, Arielle's our leader, you know what I'm saying? So she creates an environment where everybody works together. Like when she first came in, she was able to deal with everybody's personality and to, you know, to expand the unit. Now we're expanding the unit, and you know, so we work really. Everybody got like they got like no, they don't quit like they try to find creative ways. You know, we do the low hanging stuff is like easy stuff, like, you know, saying, you know, the bail fund stuff. But then if we got to litigate, the lawyers, yeah, they and, you know, they work together, they brainstorm and they strategize together. You know, so, you know, it's really, and they do trainings, all that. So I just say, like, if majority of our lawyers, if they file, like, if they have like bail situations that need to be addressed in the court and they file something, I think you know, more things will get done. As far the more we litigate, the more we challenge. Yeah. You know what I'm saying?
I mean, there's definitely, I feel like as a public defender, I feel like we have a great support system at my public defender firm. And there's always something you can be doing to be working towards release. Like I'm a big I can't say the word. Proponent. No, I'm saying it wrong. I'm a good person that believes. Proprietor. I'm a big I'm saying it. It's all right. Speech impediment, baby. I'm a big person that believes in the usefulness of PPMs, memorandums, right? So like if I have someone that's in and they currently have no pathway to get out, I believe that PPM or getting them into a program while incarcerated, so I can go to a judge and be like, hey, like this is PPM, this guy's a person, this guy has reasons to go out and come back to court. Here's a program that's willing to take him if you release him. Like those things convince judges. Like if you give a judge, even a judge who's not inclined to let your client out, a reason to hang their hat on, so they're not just releasing them for no reason. They're not going to find them in their minds, find themselves on fucking the post because this guy goes and committed a crime. Like they some of them will listen. A good amount of them will listen, but you have to put in the work.
Yeah. So that was like my approach to parole. Like instead of waiting for the parole system to say, listen, we want you to do this, we want you to do this, I was like, yo, I got a job, I'm going to school, I'm doing this, I'm doing that. So when like, for instance, you know, parole officers, they have caseloads. So, you know, you stand out on that caseload because how are they going to violate the person that's making them look good, that's doing everything right? You understand? So now, I didn't have to worry about curfew because I was going to school. So now, 9 o'clock, so you know, they're like, oh, he's good. I didn't have to worry about curfew in the morning because I go to work early. So, you know, so there's ways to get around those things. You know what I mean?
Responsibility gives you freedom. Basically.
Yeah, and it was really, and I got off of parole so fast, 2 years, and I owed them like maybe 15 years.
God damn.
So now I was, you know, and I was able to vote, or able to do all these things right out the gate. You know, they gave me the certificate of disability, relief from disability. They gave me that right out the gate because I guess they feel like. But I did have a good that last parole officer commissioner. they kind of like gave me hints like that they were gonna let me go, and they were like, you know what I'm saying? So they were like, when's your birthday? And they released me on my birthday, like, you know what I'm saying? Like, so they gave me hints, and I was, I did all the work, I prepared myself, and I was ready, and then and when opportunities came, I was able to successfully take advantage of it. And I do this work because when I was going through it, there was no one like our unit that did this work and did it in the way, like in a humane way, and and like really cared about the people that we serve, the people that look like us, So that's why I'm so passionate about this work. That's why I try to do as much as I can.
So, hopefully not to go out on a bummer note, but
it's not a bummer note. This is
no, not him. I'm segueing.
Not
a bummer note. I'm sorry.
Got out of jail, got out of Peru, got out of prison, and then got a job. This guy's a hero.
That's beautiful. I mean, hopefully not to go on a bummer note. Where do we see the Bell statue going in the future? Do you think, are you going to chip away at it again, or do you think there is a coalition of people showing that the Bell reform is working and that it's actually been doing the purpose that it was really designed for?
Yeah, I mean, I hope so. They didn't touch it this past recent budget season. They did not touch it. And so, I hope that's a harbinger of things to come. That, I mean, at this point, they've chipped away at it so much that, to do any further damage would basically be to take us back to before we even had it. And so, I hold out that hope that that's the case, but I also know that we can't subsist on just hope. So my goal and my wish and my desire for all of us is to imagine a better world, and like look at our neighbors as our neighbors, and realize, I think, what I fundamentally believe, which is, and I think if we all think about it, would also fundamentally recognize in that the safest communities, like everybody wants to be safe, that's a paramount thing that everybody desires, but like the safest communities we have are not the ones where it's the most incarcerated people locked up. It's the ones where people have what they need to live and thrive and survive. So the communities with the most resources. And I hope that as a society, we can put our focus on making sure that the least of us have what they need so that we can all be safe and thrive, and not keep trying to put a Band-Aid on these systemic societal situations, which is ultimately what we're doing by just throwing people in jail. We're not fixing the underlying problems. We are just hiding people away and perpetuating this cycle, and generation after generation after generation. And so I hope, as a community, as a city, as a country, we can really start to shape and put in the work to create the world that we deserve.
Fucking, let's get out on that note, baby. That was awesome.
I agree.
Thank you guys for being here. If there's anything you want to tell the audience before we bounce, any projects you're working on, websites you want them directing to. I know you got money to be made. tell them where to find you, Mehdi.
You can find me at esmedilaw.com or 917-905-2527.
That's it. That's it. We good?
Yeah.
Well,
you can find him in my dreams and
all right, guys. Well, that's another episode of Attorneys with Swag. If you like what you see, like, comment, subscribe, share. Hit our merch shop. You'll be able to see it right there. Buy some merch. This is a merch right here. Deduct That Shit. This is one of our songs. You can find our songs on Spotify or any other streaming services. Support the cause and support your local bail fund. We need that money to get us all out of jail. We out of here.
Should've seen it coming like a prophecy, cause the work got us moving with velocity. We beastin' now, it's some monstrosity. We the plug to the source, unshockingly. Wow, what's he really gonna do now? Jolts in your system better stay on the ground. Volts in the circus as I spark to the sound. The energy that enters me are jewels in my crown. Wow, that's how it's always gonna be. You'll never really get it like NRG. Could do without the static and the flattery. Chill for I catch a charge like battery.
No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No style, turn your energy up. No work, turn your energy up. Too wild, turn your energy up. Turn your energy up. Energy up. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy. Just energy. No weakness, just energy. Just energy. Just energy. No weakness, just energy. Energy, just energy. No weakness, just energy. Just energy, just energy. No weakness, just energy. Energy, just energy.